Welcome to this new webinar from the EU SME Center. In this webinar, we are going to explore debt collection in China, thanks to our expert Jan Olthuis. Before proceeding with the webinar, let me introduce the EU SME Center. The EU SME Center is an EU Commission funded project which helps EU SMEs prepare to do business in China. We provide different services, advice, trainings, and information to all those EU SMEs who would like to establish in China. The Center develops its activity through a network of 6 implementing partners: the China-Britain Business Council, the French Chamber of Commerce in China, Bencham, Eurochambre, the Italian Chamber of Commerce, and the European Union Chamber of Commerce in China. This webinar is implemented by Bencham, one of our implementing partners. Bencham is the most active Benelux business platform in China. It has currently over 250 members, aspiring to grow further every day. If you wish to know more about the activities of Bencham, you can visit their website. Let me now give the speech to our expert Jan Olthuis and enjoy this webinar.
Thank you, Alaria. Thank you for listening to this webinar. My name is Jan Olthuis, indeed. I'm a partner in China for Bureau Legal, which is a Dutch firm with offices in Shanghai and in Beijing. And we have quite some experience in debt collection in general and commercial litigation, more special in more complicated cases. You can read my biography in the sheet, so I will not explore that much further. And let's start with the debt collection webinar. We have several subdivisions in our webinar. First, I would like to briefly, or maybe more extensively, talk about prevention. That means prevention of non-collecting your debts. Then I want to explain a little bit about the Chinese court system and the litigation procedure, because there is a lot of information going around on how it works in China, but a lot of it is incorrect and not based on the experience itself, and often also jumps to conclusions with some prejudice. But on the other hand, it remains to be a complicated procedure for people who have no interest relating to it in the past. Then I would like to deal with, I think, the key part of the whole litigation of debts in China, which is the submission of evidence. This is really different from what we are used to in Europe, but it's a key part, and a lot of procedures fail because of lack of evidence or incomplete documentation or complete misunderstanding on how judges look at whether or not to grant a court order for outstanding debts. Then, finally, the question also remains, if you have outstanding debts and the deadline for payment of the debts is already passed, to what extent can you, according to the Chinese system, demand interest over the outstanding debts, and maybe even penalties? This is an interesting subject, because for that you don't need to have a contract in place. There are rules in Chinese system that will be applicable at that time. Then I go to the next sheet, debt collection in China. First, what is debt collection exactly? The definition often used is the legal action to collect payments from those who have received goods or services and then fail to pay, or are looking for refund of those who received the payments but failed to behave their duty. One of the most common types of litigation, in fact, because it's just based on a simple sell and purchase transaction by often SME companies in Europe selling to China because they don't have the money and time and probably cannot afford the investment to be active in China itself. So it will be most of the time cross-border transactions, but the sums can be rather big, and the inclination to take certain risks because of these high sums is there, but that doesn't mean that these risks might not materialize. Often you deal with parties who never had the intention to pay, but wanted to have the goods, and then renegotiate the whole deal as soon as the goods have arrived in China. Anyway, I will get back to that later. I should say that a lot of these transactions that eventually do not lead to debt collection could be prevented if there was a proper and maybe simple preparation and contract management in place. SMEs often do not have it. This is a pity, and it could be prevented a lot of damage if it was in place. So this webinar might also urge sales managers and SME companies to do more in the preparation of transactions on the sale of goods with China. Then I should say that debt collection by foreign parties in China have additional difficulties that you don't find in the EU countries because of the enormous language barriers and eventually a different culture in China that will jeopardize the understanding on what has been agreed and is eventually how to deal and settle difficulties when it comes to a dispute. Let's go to the next sheet. The due diligence. What can be done and what can be retrieved from existing information that is publicly available in China? You know, in China, in fact, there is much more data available than people know. But a lot of these data, of course, are in the Chinese language. And this is the biggest hurdle in order to find this information to the public sources that are available. But let me say as follows. You know, any party that is registered in China, or I should put it different, any party who wants to do business internationally in China with foreign parties need to register their activities into the system in China. And they need to set up a entity, whether or not it has legal representation or not. I mean legal liability in limited form or not is irrelevant. But they need to register. They have a kind of chamber of commerce in which you can also find information. And in the recent years, China is really undergoing a process of digitalization, not only in the company house, but also in the courts and also in a lot of additional areas where data have to be publicly available and open to the public. So if you look at these databases, you can find the company structure, the people in charge, the registered capital, the financing information. It's all readily available. And if you are dealing with a fake company, you will find out that quick enough, because then that specific person that you are dealing with should not be able to provide information who they are dealing for, and that they are in fact capable of representing the party they are saying to represent. So by asking some questions and then double checking that information, you can already do a lot in order to find out whether you have a bona fide party or not. Second, there's a lot of information available in the national courts on parties who have been engaged in the past in litigation proceedings, eventually were confronted with court orders to pay, then did not pay, and the courts were unable to enforce the claim. They are put also in a public available database, and these parties can eventually be disclosed to the public. Let's go to the next sheet. So first, let's talk about the National Enterprise Credit Information Publicity System. In the past it was called State Administration of Industry and Commerce. This is a kind of company house, you call it in the UK, or a Chamber of Commerce, you would call it in Holland and many other countries. This is a system where the basic information on the company is registered and updated. In the past, this system was sometimes very difficult to the information in the system was sometimes difficult to retrieve, because you had to appoint a lawyer who had to go in China to this administration, then retrieve the file, make copies, and find out who eventually was represented by the company, who were the shareholders, the capital, etc. That has been greatly improved in the last years, and all this information has become digitally available. A lot of lawyers have the app of this credit information system on their mobile phones and can check on the spot the details and data of the specific business organization. What can you find in this system? You find financial information, that means registered capital, but also the paid-in capital. You can see the total assets of the company, the turnover, if they register their annual reports. You can see whether they pay taxes. There might be land rights involved and mortgages over the land. You can also see records of administrative penalties. That means to what extent in the past this company might have jeopardized their license by going further in their business activities than they were allowed to, or whether they pay tax or not. This information can be retrieved. Not always you find it on the digital information, but if you really have some worries about the status of a company, you can ask a lawyer to go to the information center and then retrieve the written documentation from the file, and that can go many years back. So this is one area in which you already, without much effort, can find information about a potential partner or buyer that is publicly, and this information is publicly available. Apart from that, it's not in the sheet, you can also, if you have a Chinese reading and speaking person in your network, ask this person to check in the Chinese internet to what extent there have been filed complaints by consumers or business partners about the company. This is also very interesting additional information to be retrieved. Also, you can check the website. Famous companies are visited often by, or not often, but regularly by officials of that city or the province or maybe sometimes the national government. This means if they can say on the website that they have had this kind of visits, that most likely the company is seen by the city or the province or maybe nationally as a company that has a good track record and that the government wants to stimulate and develop. If that is the case, this company might have access to government financing, subsidies, and all kind of other incentives that other companies might not have. But this already requires some more insight into the background of that specific company. Another database that we also in our office regularly check is the Supreme Court database. This is also something very new and in fact very good if you want to know to what extent a specific company has been sued in the past and whether they eventually lost or won the case and whether there was any outstanding claim that could not be enforced against the company. You see, for instance, a few years ago you saw that a lot of steel producers had, because of financial problems, a lot of outstanding court orders that they could not satisfy just because of lack of finance. If that's the case, then in any event, if you deal with purchase orders with this kind of firms, you have to ask payment in advance or letter of credit or other security in order to be sure to get paid, because the risk will be really high. If a person is eventually, or the company is eventually not paying, it can be put on a specialist, and that would be called the database for dishonest persons. I see it's not in the sheets I have here, but a database of dishonest persons means that the specific person really is suspected to be engaged in deliberate non-payment and sometimes even fraud. At that time, if you're on this list, and this list is also publicly available, that specific person can no longer get financing, subsidies. They might even not be able to travel because their identity card will be withdrawn. And as you might know or not know, if you want to travel in China by plane but also by train, you have to show your identity card. So these persons are having some trouble following this kind of publication. Then you have the National Court Database, which in fact is the same database as I was just talking about. You will find the portal photo on one of the sheets, and you find also the court decisions website and the link on the sheet. So this kind of information is all publicly available and can give you prima facie already a lot of information on the background of a partner or a purchaser, and that means future debtor. I think the SMEs in 90% of the cases are not aware of this and therefore take in fact too much risk on the basis of the out of the blue request for purchase orders that can come from China and eventually can lead to a lot of problems. Let me now go to the next subject of this webinar, the debt collection steps. So once there is a outstanding debt, what should be the steps to be undertaken in order to formally collect the debt if the debtor doesn't want to pay? This is of course a situation you try to avoid, and you might try to settle the issue in advance. But if this doesn't work, there is no other means than to start a formal procedure. How does it work? Now, the first step is to issue a demand letter. This is a very familiar issue, but still the demand letter should be well construed and should clearly set out the facts of the case from the start and the detailed calculation of the amount of the debt, and preferably also document this information. And very important, and you will not maybe find it here in the sheet, is that you try in this stage already to confirm that there have been no quality issues that might have prevented the other party to non-payment. Because the defense against payment is often the goods are not good or they were defaulted from the beginning, and that is used as an excuse for non-payment. So it's better if from the start to already indicate in the demand letter that the goods have been received, that there have been no complaints, that the payment of the amount is just incomplete or non-existent at all, and to make from the start clear that this is only a payment issue and not a quality issue. Then I go to the next sheet. What is available in China, and that is something also not very well known, is that you can indeed seize the assets of the non-payer. In Holland, it's very easy to do it. You ask the court in one motion to seize the bank accounts or to seize company assets or whatever, and it's a one-sided motion to do. In China, you have a similar procedure. Only the difference in this case is that the Chinese courts will only allow you to seize the goods of the non-paying party if you give a guarantee. The guarantee in general might be different from location to location and from court to court, but in general they will ask 30% of the cash amount for which you request seizure, or 100% of the value of the seized lands. This is a big burden for a foreign party, because that means you have to transfer the money to the Chinese court account in order to provide the guarantee, and this is completely unacceptable and never advisable to do. However, this is a very interesting development in the last few years. There are service companies who are willing to provide a guarantee for such liability on behalf of the foreign claimant. And then you would think that these amounts are very high that they would charge to the foreign parties, but it's not high at all. What they do is they make a quick judgment of the case. So they ask some documents on the claim. If they think there is merit in the claim, they will almost without reservation issue a guarantee to the court, to the local court, saying that in the event the seizure would be illegitimate or misuse of right, they would pay for the damages as a result thereof to the non-paying party. Why would these companies do it? The reason is that as soon as the case has some merit, so there has been evidence of provision of goods and the sale and purchase has been documented in correspondence or in a purchase order or in a simple contract, the chance that you would eventually, as a claimant, be liable for such for compensation as a result of the seizure is very limited. Courts will not allow it very often. So these companies, they feel quite secure to provide such service, and the risks involved are not that high. But it is an enormous relief, of course, for foreign parties, because they could seize. And as soon as you succeed in seizure and the Chinese party would see that their bank accounts are frozen and this is really going to be serious, it is often better to negotiate a new settlement and payment will be maybe more easy forthcoming. In any event, your negotiation power will increase dramatically. Let me say something about the Chinese courts. It is said that the Chinese courts are looking at the local interests of the Chinese parties. In a certain way, maybe this is the case. But if you see the last 3-4 years, the courts and the judiciary in China has been highly improved. 3 or 4 years ago, or maybe a little bit longer, I don't know by heart, the whole system, court system and judges were re-evaluated, and the professionality of the judges has improved a lot. They received a better salary, better training, and on the whole, they have become more professional. It is true that judges are more seen as officials than independent judges. So they have eventually also obeyed the Chinese party system and eventually the cause of Chinese socialism. But if the case is merely commercial and it's about payment and non-payment and there are no sensitive issues in the matter, you can reasonably rely on a professional and independent judgment, certainly in first and second tier cities. If you go to the less developed areas in China, here the system might be still under development. and local protectionism will still occur. But on average, the system has improved a lot. Then the IP-related cases, of course, this is not relating to debt collection. IP is really, the national government is really doing an effort to improve protection. They have set up special courts, and the judges are very much trained to deal with trademark and patent and secret know-how in trade information protection. On average, that is already a big improvement. When a foreign party goes to court, also the base of, that means the court level will not be the local court but the intermediate court that deals with the somewhat complicated cases, and foreign parties are having a special status in the whole procedural system, and therefore they will not go to the lowest level, but they go to the intermediate court level. If they lose or win the case, there is a possibility to appeal to the appellate court, and eventually parties can go to the Supreme Court, but that is really an exception, certainly in simple commercial cases. Then I go to the next sheet. Eventually, as I said before, the intermediate court will be the court that will deal with cases that have a foreign interest, and this will prevent the foreign party to go to the local courts. But if you didn't agree on the jurisdiction of a certain court and nothing has agreed at all, you have to go to the place of the debtor, and that might still be a local court somewhere in mainland China. It can also be, of course, Beijing, Shanghai, but you have to go to the place where the debtor is located. There is nothing to be done. What I should say here is that it is a misconception also to think that in international purchase and sale agreements it would be a protection for the foreign party to say that the court in the foreign country would have competence and jurisdiction to deal with the case. Why? If your contract would say, let's say it's an Italian seller and a Chinese buyer, if the contract would say, in the event of a dispute you have to go to the competent court in Italy and the matter will be judged according to Italian law, this might lead to a judgment and a court order in Italy. But the problem is that this court order in Italy cannot be executed at all in China. So if you want to go to the debtor in China, you cannot use this award at all. You have to redo the case completely after you have done it in Italy, which only costs you double amount of money, and the Chinese judges will give a toss on what the judges in Italy have decided or not, because they will determine their own case. On the other hand, if the Chinese party has a problem, for instance, that they say that the quality of the goods is not okay, they can go to Italy and execute eventually a award against the Italian party. So it's a very one-sided situation. So it's better not to agree on this kind of national jurisdiction and law clauses, and or decide that the matter shall be dealt with in arbitration, and arbitration awards can be executed in China contrary to national court orders, and that or that the Chinese court, maybe in a larger city which is more professional like Shanghai or Beijing or Guangzhou or maybe Chengdu, will deal with the matter. Let's go to the next sheet. Litigation itself. I will be brief on it, but the case should first be accepted by the court. Then the court will look at the information provided by both parties and decide whether there is a claim or not. If there is a claim, the matter will be registered, and parties are invited to submit in writing their positions. Then the judge will hear or determine a court hearing. Usually 1 or 2 times might be enough. And in this court hearing, the judge will call the shots. So it's completely not the same as you will see maybe in UK legal proceedings or in civil law countries. Here the judge knows the law. They really are not so much interested in the legal position because they will indicate to the lawyers involved during the hearing that they know the law. Maybe they have some specific questions. And then all the remaining time in these hearings is dealing with evidence. So what has been agreed on paper? Are there any emails? Is it legalized, the documentation, if it is signed in a foreign country? And this is the big hassle of the whole litigation procedure. It's not so much the law. The law is often clear. But what has been agreed, and has it been explicitly agreed between the parties? And can the evidence eventually be reliable or not, is the key question. So if this contract documentation, and I will get back by this issue of evidence in more detail, because it's really the whole key of being successful or not successful in litigation proceedings in China and debt collection proceedings as a result. If the contract documentation is in order and there are no quality problems, then it should not be difficult to get a payment order. If you don't agree with the eventually decision, there is a possibility for foreign parties to appeal within 30 days and have a partial retrial of the matter. There are a lot of other things to be said about these proceedings, because the way they go from a legal aspect is a little bit different from ours. But in this framework of debt collection for SMEs, it might be too detailed to deal with it now. Let's go to the next sheet. The circumstances of the case. Here, of course, you have to consider a few things. First, if the order is, or if the outstanding debt is not so high, is it worthwhile to spend the money? This is something you have to decide based on the situation, of course, and the location of where the collection should take place, and the time you are willing to spend on getting the money back. There's a lot to be said, but there are also lawyers, a lot of lawyers in China who are willing to do the case no cure, no pay. Our firm will not do it because it will give too much an interest in the outcome of the case, and it is not always the best service you get. But this is a possibility to do in the smaller claims. When the claims become bigger, it's better to consult an experienced lawyer, because a lot of things can go wrong in this kind of proceedings. With respect to timing, a foreign party procedure has not really a time limit. That's why, especially in the gathering and submission of evidence, there can be long delays. And a case can easily take 1 year or maybe longer if a foreign party is involved. Let's go to the next sheet. I will skip this sheet. It just deals with additional cost relating to litigation. Of course, one point is important, and that is to check whether the debtor indeed has tangible assets and has any recourse if you would win the case. If it's already clear it's an empty shelf and it can be abandoned easily after a few weeks, then you might win the case and eventually end up with a case against an empty asset company. So this would not be worthwhile. So some due diligence before starting the case on the value of the assets of the debtor is, of course, very important. Then the preparation of court documentation. One of the issues that are really important is documentary evidence. This is the key. In fact, and maybe I should not say it so loud, but it's a key matter, judges do not really trust the parties nor the lawyers involved. There's a lot of fake documentation going on, frauded documentation, and the main issue during the whole procedure will be whether the evidence submitted is reliable, is original, and what the content of this evidence has and the implications as such. All the information, even when it is an international contract, should be submitted in Chinese language version. So all of this should be translated into Chinese by a registered and certified Chinese translator. The local courts have often a database of acceptable translators, and this service has to be retained. In addition, if there is a foreign document, this document needs to be legalized. That means it should be confirmed for true copy, and that confirmation should come from a process in which eventually the Chinese embassy in the country involved will confirm that the document is original. I will also get back to evidence of email correspondence, to what extent this can be submitted, and it will give you a better understanding on how the evidence material is regarded by Chinese judges. One point in this effect is that, contrary to what we are used to, the judges in China are easily accessible. So in the cases you will have the mobile phone of the judge. You can just call him without the other party knowing and indicate some worries or ask for an extension of a deadline because of all kind of reason. On the other hand, the judges might also take the liberty to call the parties and try to push them into a settlement, already indicating in an early stage what their thoughts on the case are and to what extent they think the settlement would be preferable. This is very informal. It's completely in our, let's say, rule of law framework of thinking, out of the question that one party can contact a judge without the other party knowing, because you can never know what one party is saying, and the other party should have the right to reply or refute certain statements of facts. In China, this is all very informal and often also very practical. So it's not necessarily that one party would misuse the situation, but it's from a practical point of view in which judges try to deal with the enormous quantity of cases. Very practical to force parties or to push parties into settlement if they think that a judgment can be avoided. So this is a very particular aspect of the whole Chinese judiciary process. Sometimes it's good, sometimes it is less good, but our experience is that it might in some cases be very helpful to know already in an early phase how the judge is looking at the facts and the evidence and give some guidance on how to bring the matter to an end. Then let's go a little bit further on the evidence rules. So if you have no clear payment terms and no clear purchase terms, what should you do then? And this is very often the case. I think especially with SME companies where there is not always a good document management and contract management system, and where sales managers are really looking to bring the purchase order in and might ignore the fact that maybe the contract is not so solid. So what is the problem and what is the issue? So often often in circumstances there is no written contract, or a contract is not stamped and signed. So there's only exchange of some drafts, and then eventually the draft is not executed. So that means if you don't have a signed contract, the judge will just look at each contract term and see whether this is explicitly agreed by circumstantial evidence or by maybe acknowledgement by the parties in the submissions to the court. But they will not take such a document as evidence. So this is not very good if you don't execute an agreement. Then it can be that the contract is only stamped. You might know that in China the stamp is more important than the signature. So if you have a stamp on the contract is considered to be properly executed. But you have to ask for an original. Otherwise you will have again a problem in the evidence. If the contract is not chopped and the Chinese signature signed with his unofficial English name, this can happen too. At that time, for instance, the contract is signed with Robert or Richie or whatever, but not with the Chinese name. Then at that time you might have a problem as well, because you need additional authentication. That means other evidence showing that the person involved was really able to represent the company, and that this English name really represents the person with the Chinese name, because in China only the Chinese name has authorization, not the English name. Other point, if you have no original copy available, then the authenticity of the contract needs to be proven by a paper trail. This might be available, but it requires a lot of additional work in order to prove that parties were intending to agree upon the terms of this non-signed original copy, or maybe a signed copy but not original. That's what happened also in the past, that we could prove that we had a scan of the contract, but we didn't have the original. Then the other party would say, look, this might be a fake contract, we ignore the existence, and the judge should ignore the existence, and eventually the judge did ignore the existence. It's very, very painful to experience, but it happens. So I have some more in the sheets examples. It might well be that also the contract is signed by the salesperson but not the legal representative of the specific company. Then that is a principle that is ignored also in practice, that eventually the company should sign such an agreement with the formal company stamp, and the person who is signing should have authorization to sign. So if this is not the case, the eventual debtor can just rescind the contract saying, look, we never intended to, the salesperson acted ultra vires, as you say in practice, and the contract is not valid, so we are not bound to it. In most of the cases, the whole contract intention is done through emails, because people will not send over contracts from China to Europe and the other way around. So the deal is sealed with emails. What is the value of an email in the Chinese court? It's very interesting. In fact, or you have to take your computer or your laptop to the judge and show the email on your computer. He will just have a look and see whether the system really has this email in place and it's part of a normal email box and there is an email chain with all the related information in it, and then they might accept it. Or you have to go in Europe to a civil notary and ask the civil notary to check whether the computer indeed has these emails in its database, then make printouts of these emails and then let them be legalized by the notary. Only if you do it this way, the emails can be accepted. It's contrary to what we know in Holland and in other courts, where just a printout of the email might be taken on face value as some proof. In China, it's not the case. Then I come to the next subject, which is that if you have an outstanding payment, can you also calculate interest on top of the payment itself? The answer is, if interest is not agreed, the lending rate of the People's Bank of China will apply. And that means you can calculate the interest as from the date that the payment should be due up to the date of payment. It's between 4 and 5%. In the sheet you can find the more specific rates. It depends on the outstanding period or term of the payment. If it's shorter than 1 year, it will be 4.35%. If it is longer than 5 years, it's now 4.9%. It is maybe a better rate than you would get nowadays in many EU countries. So this calculation might be helpful, and certainly over a period of years of outstanding payments, it can accumulate to a substantial amount. Then, can there be calculated penalties on top of the interest? The answer is yes, it can be done. Maximum 30 to 50% on the accrued interest rate can be charged on top of the normal interest as penalty. And we cited some cases in which this was awarded, and it's general practice to do it. But you can find that per court the maximum penalty might vary. And that is why you always have to take into account the court where you are suing the Chinese party. They have their own characteristics. They are not so difficult to find out, but it might be worthwhile to check it. Then we come to the enforcement and almost the end of this webinar. Enforcement is also rather different from what we expect in EU countries. Many EU countries, they would have a bailiff who will take over the enforcement from the court and have the means also to take action against a debtor and execute a court order. In China, the enforcement is done by a special division of the local court. They have nothing to do with the court, with the division that eventually granted a payment order. So the case is just transferred to the enforcement division of the local court, and they will start to chase the defendants or the plaintiffs to make payment. These judges, they have special rights, so they have access to the bank system of the state-owned banks, and they can see very quickly whether there's money on the account. They have the right to seize assets and to sell, so they have all the assets. The only problem is that they are overcharged with work, and here, if there are local interests at stake, you will find and might find difficulty in that the judges might not do a very good job, let time pass and try to suspend the whole matter. And this is a process where it's very difficult to have, as lawyers, influence upon. But you can help the judges by also do a check of the assets and provide this information to the judge. So you can see to what extent the specific company has shares in other companies, or you can know where assets are located, or maybe you know that they have real estate. This can all be provided to the enforcement judges, and they might follow it up because it would relieve their tasks and work. But again, this is an area that is not easy and might in some areas be a little bit dodgy. But if you are persistent and the judge knows that he will not be off the hook in this specific enforcement case, then you can reach certainly certain results. Then I come to my last two sheets, the takeaways of this debt collection webinar. First, the key, I think, to debt collection lies really in the due diligence you have to do before you start to deal with the Chinese party. As I've indicated, there's a lot of information available in the Chinese databases that can be quite easily retrieved. There are fake companies acting to buy huge orders of goods, but if you check these databases, you will find out they are fake very quickly. So not doing this would be really a shame. Second, if you don't know the party, you should really avoid open account. And I know that this might be difficult because the Chinese party might not want to buy if they don't get a certain credit and payment relief. But that is part of the game and the trick also to lure you into a big order. So if they are not willing to make a prepayment and want everything on open account, you should better be warned that this risk is created maybe deliberately. And then if you're talking to my third point, if you're talking to large orders, then you can ask Chinese window companies. I don't know whether you've heard of it, but there are a lot of larger state-owned import-export companies who might act as an agent in the transaction. That means that the local company will sell the goods first to this window company, and the window company will resell it abroad and take a certain commission on the total order. In fact, these Chinese window companies know whether the domestic company is reliable or not, and they make their own judgment on whether that company would pay. So it would make matters much more easy, and certainly if you would decide to enter into a sales order open account, to not do this with a smaller local domestic company, but ask a Chinese window company to be the intermediate. The intermediate companies will do it at a certain charge. That means they take, as I said, a commission. It's between often 1 and 2%. It's I think, a good investment to reduce your price with 1 and 2% if you are able to get a reliable payer instead of an unclear domestic company as your contract partner. Then, second part is to do the document management properly. So insist to have a signed and sealed contract and ask for a original, properly chopped, and that eventually agree on a dispute settlement by a Chinese court that is not located at the place of the debtor. You can just draft that in the purchase agreement so that you take a dispute really out of the comfort zone of the specific debtor. And this might already have a certain disciplinary effect on the payment behavior of the debtor, because they know if matters go wrong, they might not be very able to influence the outcome of a court proceeding. As I indicated earlier, please don't state in your contract that the jurisdiction is in your own foreign country and that the local courts in your own country will deal with any dispute, because you will not receive an enforceable order. And there is a reason to say, let's just try not to get Chinese courts decide with any dispute and bring the whole matter into the jurisdiction of an arbitration commission. There are several arbitration commissions in China. There are also international arbitrations outside China. The arbitrations outside China are very expensive eventually, but the arbitrations in China are cheaper. And the good thing of this kind of arbitration in China is that you can stipulate in your contract that the proceedings are going to be in the English language and not in the Chinese language. This gives you a possibility to far better understand the arguments of the other party and to also far better bring your own arguments and check the arguments that will be provided to the Arbitration Commission because they can be done in English. So CITAC, which is the China International Economic Trade Arbitration Commission, and SIAC, which is the Shanghai International Arbitration Commissions, are really options to consider. Thank you very much for listening to this webinar, and I hope it has been useful.
Many thanks, Jan, for sharing your knowledge around debt collection in China. And if you have any other further question or any advice is needed, you can contact us through our website that you can access through this slide.